Welcome to the deep dive. Today, we're taking a serious plunge into, well, the very foundations of company law, corporate legal personality, and limited liability.
Absolutely fundamental stuff.
Yeah, exactly. So if you're studying this, maybe, prepping for exams or just really curious about how the law actually sees businesses, this deep dive is pretty much built for you. We've pulled together some fantastic resources to untangle these absolutely essential
They
ideas.
really are essential.
Just a heads up before we jump in, the material we're drawing from today comes from documents generously made available for educational purposes by the University of London.
Yes. Big thank you to them.
Huge thank you to them for helping make this kind of learning accessible. And please do remember, this deep dive is strictly for educational use only.
hmm
This deep dive is proudly brought to you by Sinorbit Academy, Sri Lanka.
Right. So when you get into company law, these two concepts, corporate legal personality and limited liability, they really are the pillars everything else rests on.
The bedrock, really.
It is. And understanding them isn't just, ticking a box for exams. It's fundamental to grasping how companies function in the real world, how they own property, make deals, handle debt.
Makes sense.
So our mission today really is to make sure you walk away knowing exactly what these terms mean, seeing their power and their consequences through some landmark court cases, appreciating the economic arguments for and against them, and hopefully feeling ready to tackle any question they might throw at you.
Okay, let's unpack this then. Let's start with corporate personality. When the law grants a company personality, what does that actually mean, legally speaking? Are we talking feelings?
No, not feelings, thankfully.
Yeah.
What corporate legal personality means is that, under the law, a registered company is treated as a separate legal person.
A separate person.
Yes. Think of it like this. Once it's registered, the company exists as its own entity, completely distinct from the people who own it, the shareholders, or members, as they're sometimes called.
So it's not just a label for the group of owners, it's genuinely its own legal thing.
Exactly. And because the law creates this separate legal person, it has some pretty significant, almost mind-bending consequences.
Okay, like what?
Well, because the company is a separate person, it can itself own property. The factory, the computers, the bank account, they belong to the company,
Not the shareholder.
not the shareholders directly, no.
Yeah.
And the company can enter into contracts itself, with employees, with banks for loans, with suppliers, other businesses.
Okay.
And crucially, the company itself is liable under those contracts. The company owes the money. The company is bound by the agreement.
Right. So the liability stops with the company, doesn't it? That's a huge difference compared to, say, a sole trader where their personal house could be on the line.
It is a massive distinction. And it's actually fascinating to trace where this idea came from. It didn't just appear overnight. The concept of entities being separate from their members goes back centuries. Think about religious orders or maybe local authorities holding property. But the modern commercial company's legal personality, especially when tied up with limited liability, that really took hold with the company's acts back in the mid-19th century. That made registration much more accessible.
Okay. And this leads us to where it gets really interesting, I think. The absolute foundation, the case that cemented this whole idea of separate corporate personality, even for what looked like a one-man show, is Salomon v. Salomon & Co. You absolutely have to know this one, right?
Oh, absolutely. Salomon v. Salomon & Co., decided by the House of Lords way back in 1897. It's the defining case.
So walk us through it. What happened?
Okay, so let's look at the facts from the material. Mr. Salomon, right? He had a successful boot and shoe manufacturing business, running it as a sole trader, doing well. Then in 1892, he decides to incorporate. He forms a company called Salomon & Co. Ltd. Now, the law back then said you needed 7 shareholders. So to meet that technical rule, he, his wife, and his 5 kids each took just 1 share.
Just to tick the box, basically.
Pretty much. Then Mr. Salomon sold his existing successful business to this new company he just created. The price was about £39,000, quite a sum back then.
And how did the company pay him?
Ah, that's key. It paid him partly in shares, but also importantly in debentures. Debentures are basically a type of loan, often secured against the company's assets. So, in effect, he became a major creditor of his own company.
Right. So legally, you've got this company structure, shareholders, debentures. But practically speaking, it's still Mr. Salomon running the show.
Precisely.
Yeah.
He was in complete control, but then the business ran into difficulties. And the company eventually went into insolvent liquidation. It couldn't pay its debts.
And the other creditors weren't happy, I imagine.
Not at all. The unsecured creditors, the ones without security, like Salmon's debentures, looked at this whole setup and basically said, hang on a minute.
They saw Salomon potentially getting paid first from the assets because of his debentures, right? And thought, this company's just a front. It's just Salomon in a legal disguise.
That was exactly the argument the liquidator made. They claimed the company was a sham, or just Salmon's agent, his alias. And therefore, Salmon should be personally liable for all the company's debts, just as if he'd never incorporated.
Makes intuitive sense, maybe. What did the court say initially?
Well, the Court of Appeal actually agreed with the liquidator. They felt the shareholders weren't a genuine bona fide association. They looked past the legal form.
But that wasn't the end of it, was it? The House of Lords.
The House of Lords took a very different and ultimately landmark view. They looked strictly at the Companies Act. Their decision essentially swept away that idea of the company being a sham or an agent just because one person was in control.
What were the key points from their ruling?
Two main things. First, the reason why Salomon had those other 6 family members as shareholders, basically, the technicality was irrelevant in law. The Companies Act allowed a company to be formed this way, even if it functioned like a one-man business.
Okay.
Second, and this is the absolute core principle, a company, once it's properly registered according to the Act, is a separate legal person. It is not the agent or trustee for its shareholders or its controller. Full stop.
So the company's debts belong to the company, the separate legal person, not to Mr. Salomon personally.
Exactly. The company owed the debts. And flowing directly from that principle of separate personality came the confirmation of limited liability for the members. Salomon, like the other shareholders, couldn't be forced to pay the company's debts from his personal money beyond whatever was unpaid on his shares.
Wow. So Salomon is the authority. A company is separate even if controlled by one person.
That's the takeaway. Salomon v. Salomon & Co. establishes that fundamental principle. Separate legal personality, distinct from its members, no matter the control structure.
Yeah. Okay, so for you listening, thinking about exams or just getting this straight, what's the absolute key point from Salomon? It's that core principle. Separate legal personality, really get that. And then you can see how limited liability for the owners is a direct consequence, flowing naturally from that separation.
That's right. And that principle of separate legal personality becomes even clearer when you see how it plays out in other situations and other cases that really test its boundaries.
Good idea. Let's look at some. First up, Macara v. Northern Assurance Co. This one seems brilliant for showing who actually owns the company stuff.
Yes, Macara.
Oh,
It's a classic from 1925, really highlights the separation of property. So the facts. Mr. Macara owned a lot of timber on his land.
Okay.
He then formed a company. He held all the shares, total control again, and he sold all that timber to his company. So now, legally, the company owned the timber.
Right.
Then Mr. Macara took out an insurance policy against fire for the timber, but, and this is the crucial bit, he took the policy out in his own name, personally, not in the company's name.
Uh-oh. I think I see where this is going.
Exactly. The timber burns down. A total loss. Mr. Macara tries to claim on his personal insurance policy.
And the court said,
The court said, nope. The timber belonged to the company, the separate legal person. It did not belong to Mr. Macara, the shareholder. Even though he owned all the shares, the assets owned by the company were the company's assets, not his personal property.
so you can't insure something in your own name if the company actually owns it.
Precisely. A shareholder owns shares in the company. They don't own the company's assets directly. There's no legal or equitable interest there. Macara just hammers that home. Company property is separate from shareholder property, distinct buckets.
Which makes total sense then, thinking about it the other way around. That separation means a shareholder can actually deal with their own company, right? Like rent property to it.
Exactly.
Yeah.
Because they are two separate legal persons. If I own a building personally, and I also own all the shares in my company, I, the individual, can legally enter into a lease agreement with my company, the separate entity. We can have a contract. Which leads us perfectly to the Lee case.
Ah, yes. Lee v. Lee's Air Farming. This is the one from 1961 that always seems a bit, well, counterintuitive. Can you really be employed by a company you totally own and control?
It does sound odd on the face of it, doesn't it?
Well,
But
yeah.
again, it's just a logical application of the Salomon principle. So Mr. Lee formed Lee's Air Farming Ltd. He owned all the shares. He appointed himself the governing director for life. And crucially, the company also employed him as its chief pilot. He drew a salary.
Okay. Owner, director, and employee.
All roles held by the same individual but legally interacting with a separate company. Tragically, Mr. Lee was killed while flying the company's aircraft, doing his job as chief pilot. His widow then made a claim for workers' compensation under the relevant legislation.
Which depended on him being classed as a worker, an employee.
Exactly. The critical legal question was, could Mr. Lee, who effectively was the company in practical terms, legally be considered a worker, employed by that company? Did an employment contract exist between these two? Well, could it exist? It all hinged on whether the company and Mr. Lee were truly separate legal entities capable of contracting with each other.
And the ruling?
The Privy Council, which heard the appeal, said yes, unequivocally. They upheld the Salomon principle. Mr. Lee and Lee's Air Farming Ltd. were distinct legal persons. Because they were separate, they could enter into contractual relationships with each other, including a valid employment contract.
Even though he was essentially giving orders to himself.
The court acknowledged that. They said the fact that Mr. Lee, wearing his director hat, could give orders to himself wearing his pilot hat didn't change the fundamental legal reality. There were two separate legal entities, and they had a contract. His widow got the compensation.
So, Lee v. Lee's Air Farming is the case that proves it. Separate personality means a company can contract even with its sole owner-controller, including for employment. Wow.
Right.
Okay, so Salmon, Makara, Lee, they really paint a clear picture. The source material also mentions some other modern cases, right? Like Barings, Giles v. Rind.
Yes, they're mentioned as further examples reinforcing the same core idea.
Yeah.
For instance, the idea that if a subsidiary company suffers a loss because of something a third party did, it's the subsidiary as the separate legal person that suffered the loss that has the right to sue, not the parent company's shareholders just because their investment value went down. The company's rights and its obligations are its own.
The principle holds firm.
Okay.
Now,
Yeah.
building on this idea that the company has its own liabilities, this makes it easier to grasp the next big concept, limited liability. How do they connect, but how are they different?
Okay, good question. They are definitely connected but distinct. Separate legal personality is what allows the company to incur its own liabilities in the first place. It's the company that owes the debt, remember?
Yeah.
Limited liability is then the consequence, or maybe the shield, for the shareholders. It protects them from having to pay those company liabilities.
Okay.
So limited liability means that if a limited company goes bust, becomes insolvent, and can't pay all its debts, the shareholders cannot be forced by the company's creditors to dip into their own personal pockets, their personal wealth, to make up the difference.
So their risk is capped?
Exactly. Their financial exposure, their potential loss, is limited. Hence the name limited to the amount they originally invested to buy their shares, plus any amount that might still be unpaid on those shares if they weren't fully paid up initially.
Okay, right. So I might lose the money I put into the company if it fails. The value of my shares goes to zero. But my house, my car, my personal savings account, stuff that belongs to me, the separate individual person that's safe from the company's creditors.
Precisely. Your personal assets are shielded. Your loss is capped at your investment in that specific company. Now, this concept, limited liability, while it sounds great for shareholders, it obviously raises a big question. Is it actually a good thing overall? For the economy, for society?
Yeah, I can see the potential arguments.
Well, the source material points to economists like Easterbrook and Fischel, who've made some really powerful arguments for limited liability, explaining why it's so common and, they argue, economically beneficial.
Okay, what are their main points?
One major argument is that it shifts risk. It shifts the risk of business failure away from the shareholders' personal wealth and onto the company's creditors, or rather, onto the business venture itself.
How does that help?
By limiting the potential downside for investors and entrepreneurs, it makes people much more willing to take risks, to start new businesses, to invest capital in ventures that might fail. It encourages enterprise.
Okay, so it greases the wheels of business creation. Makes sense. What else?
Second, they argue it encourages investment from what you might call passive or sleeping investors, people who have money to invest but don't want to be involved in the day-to-day management.
Right, they just provide capital.
Exactly.
Oh.
Without limited liability, these passive investors would be risking their entire personal fortune based on management decisions they have no control over. Limited liability makes it much safer and more attractive for them to invest.
Okay, encourages investment.
And third, Easterbrook and Fischel argue it encourages the dispersal of investment. Limited liability makes it much easier and less risky for people to buy small amounts of shares in many different companies, diversifying their risk.
Ah, like building a portfolio.
Yes. And this widespread share ownership facilitates the development of active, liquid stock markets. These markets, in turn, help allocate capital efficiently across the economy and can also play a role in monitoring how well company managers are doing their jobs.
So those are pretty strong economic arguments for limited liability, especially thinking about big public companies with thousands of investors.
They are very influential arguments, yes. But the source material also rightly prompts you to think, do these benefits apply with quite the same force to small private companies?
Hmm.
Like Mr. Salomon's original setup, essentially a one-man band using the corporate form. It's a really good question to mull over. Does limited liability make as much sense there?
Yeah. And while limited liability is framed as economically good, it's hard not to feel.
Well, doesn't it just seem unfair sometimes? Especially to the creditors, the suppliers, the lenders who give credit in good faith. And then, if the company fails, they might not get paid back and they can't chase the owners personally.
That tension is absolutely real. It's the flip side of the coin. And the source material mentions scholars like Hansman and Crackman who discuss this creditor perspective.
So what's the counterargument there?
Well, while it's true that creditors of a limited company can't go after the shareholders' personal assets if the company fails,
Hmm.
you have to remember what separate personality gives the creditors to.
Access to the company's assets. And critically, the company's creditors generally have priority over the shareholders' personal creditors when it comes to claiming against the company's assets.
Ah, okay. So the company's pot of money is sort of ring-fenced primarily for the company's debts before the owner's personal creditors can get near it.
In essence, yes. The company's assets stand first for the company's debts. This actually makes lending to companies potentially simpler in some ways. A lender can assess the risk based mainly on the company's balance sheet, its assets, its business prospects, rather than having to investigate the personal financial health and potential personal debts of every single shareholder, which would be impossible for a large company.
Right. You lend based on the business, not the owner's personal lives.
Exactly. Plus, you have to remember that most creditors, especially commercial ones like banks or large suppliers, choose to deal with a limited company. They usually understand the implications of limited liability.
And they can factor that risk in.
They can. They can adjust their terms accordingly. Maybe they charge a slightly higher interest rate on a loan to compensate for the risk. Or perhaps they insist on taking security over some of the company's assets, like a mortgage over its property, or a charge over its equipment. Or maybe they ask for personal guarantees from the directors in smaller companies.
So they aren't always completely unprotected.
Not always, no. They often have ways to mitigate the risk. So yes, while limited liability is incredibly powerful economically and largely explains why the limited company is the dominant form for business, it definitely creates situations where creditors can lose out, sometimes significantly. And this inherent tension is precisely why the law sometimes, in very specific exceptional circumstances, allows courts to lift the corporate veil or pierce the corporate veil.
Okay. Ignoring the separate personality.
In effect, yes. But that's a whole complex topic for another day. The key point here is that veil piercing exists, in part because of the potential unfairness limited liability can sometimes create for creditors.
Right. Okay. So let's bring this all back home. For someone studying this, trying to get a real grip on it for exams or just for understanding, what are the absolute must-knows from this chapter?
Okay, key takeaways for you. To really master this chapter, feel confident, there are a few non-negotiable things you absolutely need to lock down.
Lay them out for us.
First, obviously be crystal clear on the definitions.
Yeah.
What is corporate legal personality? You need to be able to say, the company is treated by law as a person separate from its owners.
Got it. Separate person.
And what is limited liability? You need to explain. It's the principle that shareholders' liability for company debts is limited, usually to the amount they invested or agreed to invest in their shares.
Okay, definitions first. What next? And tied to that first one, make sure you can list and explain the key consequences that flow directly from corporate legal personality. The company owning property itself, the company entering into contracts itself, the company being liable for its own debts.
Yes, exactly. Then absolutely crucial. Know the key cases. Salomon v. Salomon & Co. is your bedrock, your foundation. You need to understand the facts, what the liquidator argued and why it failed, and most importantly, the House of Lords decision establishing that core principle of separate legal personality, even for a one-man company. No Salomon inside out. Repeat, no Salomon.
Got it. Salomon is king. Then the other cases.
Yes, use the other cases to illustrate the consequences of Salomon. Use Macora v. Northern Assurance Co. to show how separate personality applies to property ownership. Shareholders don't own the company's assets. Remember Macora for property.
Makara property. Okay.
And use Lee v. Lee's air farming to show how separate personality allows the company to enter into contracts, even an employment contract, with its own controller. Remember Lee for contracts with the controller.
Lee contracts. Got it. Salman Makora, Lee.
Exactly. Finally, you need to understand the debate around limited liability. Be ready to discuss the economic benefits, those points championed by Easterp and Fischel, you know, encouraging enterprise, passive investment, efficient markets.
The pros.
The pros, but also be aware of the creditor perspective, the potential downsides, acknowledging their risks, but also the protections they do have regarding company assets, perhaps drawing on ideas from Hansman and Crackman. Understand both sides of that argument.
Right. So know the concepts, know the key cases that establish and illustrate them, and understand the economic debate around limited liability. And to really test your grasp, that activity mentioned in the source material sounds useful. If you're incorporating your existing sole trader business and you personally own the building it operates from, should you sell the building to the new company? Or should you keep owning it personally and just rent it to the company?
That's a great application question.
Yeah, thinking through that forces you to apply the ideas from Akara about separate property ownership and the ideas from Lee about being able to contract with your own company, doesn't it?
It really does. If you can confidently define the terms, clearly explain Salomon and its key consequences as shown in cases like Makara and Lee, and then discuss intelligently the benefits and potential costs of limited liability, well, you've got a fantastic handle on this crucial area of company law.
It's definitely meaty stuff, as you said, but breaking it down like that, core definitions, the main case, the illustrative cases, and the economic discussion makes it feel much more manageable.
Absolutely. And as a final thought, something to maybe chew on after this,
Hmm.
there's a quote sometimes used to provoke debate, drawn from commentary on the Salomon decision. It goes something like this. The Salomon decision was a scandalous one, which unleashed a tidal wave of irresponsibility into the business community.
Ooh, strong words. Scandalous. Irresponsibility.
Strong words indeed. So the question for you is, do you agree or disagree with that statement? Think back to the facts of Salomon. Think about those economic benefits of limited liability we discussed. Think about the potential unfairness to creditors. Think about how the law maybe tries to balance things now, like with veil piercing in rare cases. Grappling with that provocative statement using the principles and cases we've covered today is actually a brilliant way to consolidate your understanding and prepare for potential essay questions.
That's a great challenge. Okay, well, thanks for diving deep with us today. We really hope this session has clarified these absolutely critical concepts for you.
Yes, hope it was helpful. Getting a solid grasp of corporate legal personality and limited liability right now at this stage will genuinely make so many other areas of company law much, much easier to understand down the line. You've built a strong foundation here.
This has been a deep dive into corporate legal personality and limited liability, brought to you by Sinorbit Academy, Sri Lanka.
And made possible, of course, by the excellent educational resources provided by the University of London.
We'll catch you on the next deep dive.